I'm L.A. Perkins, a brand protection attorney strategist. I help business owners and entrepreneurs identify and protect their intellectual property assets and enforce their rights. As a business owner or entrepreneur, one of the first things you need to do is protect your brand. Not doing so can cost you hundreds of thousands of dollars or more in the future, and it can even result in you not being able to conduct business going forward. When you have a great brand for a product or service, there will always be people who want to duplicate your success and use your brand as their own. And just because you might have gotten there first does not mean that your brand is necessarily protected. Companies of all sizes are at risk for having their unique brands for products or services infringed upon. These are the top 10 mistakes that business owners make thinking their brand is protected, and in reality, it is not. Mistake number 1. You register your company's name as a legal entity with the Secretary of State in your particular jurisdiction, and you think that that gives you right to the exclusive use of that name. The truth is, this does not protect your brand rights. It simply allows you to conduct business in that particular state using the registered name. Mistake number 2. You purchase a domain name, which is your company's brand name, and you think that that gives you exclusive rights to use that name. The truth is that registration of a domain name does not provide you with brand rights to that name. Instead, it simply provides you with a web address for your company's website. Mistake number 3. You start using a brand name and you think because you used it first, another company will not be able to use the same brand name. The truth is, if you're not first to file a trademark application, another company may do so before you do and obtain a trademark registration. Mistake number 4. You, based on your personal knowledge, are not aware of any other company using your brand name, so you think the coast is clear to proceed with filing a trademark application with the United States Patent and Trademark Office. The truth is, a company you are unaware of can file an objection to your trademark application and block you from being able to obtain that registration. They may also be able to block you from continuing to use the trademark you are seeking to protect. It is most prudent to do a comprehensive trademark search with the assistance of an experienced trademark attorney to assess the risk in moving forward with the application. Mistake number 5. You proceed with using a brand name without doing a comprehensive search with the assistance of an experienced trademark attorney. The truth is, you could be infringing on another company's intellectual property rights. This can subject you and your company to being sued and having to pay thousands of dollars and stop using your company's brand name. Mistake number 6. You do not know what IP assets you have, and therefore you have not taken steps to protect those assets. The truth is, this can result in you not having leverage to stop another company from infringing on your IP assets. Mistake number 7. You file a trademark application where you provide dates of first use, but you don't really understand the meaning of dates of first use, and you provide the wrong dates, and you don't keep the evidence that supports the date of first use. The truth is, if your trademark rights are challenged down the road and you are unable to prove that the dates of first use that you provided were correct based on the evidence, you can actually lose your federal trademark rights. Mistake number 8. You have not budgeted for the expense of brand protection because you don't think it's a priority. This can come back to haunt you if another company obtains federal trademark rights for the same brand name, preventing you from being able to do it in the future. Mistake number 9. You have a United States trademark registration and you think you are protected if you sell your goods or services outside of the United States. The truth is, if you are selling your goods or services outside of the United States, your U.S. federal trademark registration will not protect you in those jurisdictions, and you'll need to apply for protection in each jurisdiction in which you are doing business. Mistake number 10. You think it is not necessary to use an experienced brand protection attorney to help you in obtaining your trademark registration, and instead you think you can do it on your own or use a non-lawyer service. The truth is, you are more likely to obtain a trademark registration if you use an experienced brand protection attorney to assist you. Is your business protected or do you have exposure? Most business owners have no idea how much exposure they actually have, and that's why I created a free brand protection assessment. If you're conducting business or plan to be with a unique brand name, then make sure you are protected and schedule a free brand protection assessment. In it, we will do a 20 to 30 minute review of the brand assets on your website and lay out a specific plan of action moving forward. Schedule a time to meet with me today and get your brand armor on.